Welcome to Dementia-Friendly Prince George's County, Maryland Northern Sector webinar series for caregivers. Today's topic is Medicaid myths and must-have documents to avoid guardianship. Sponsored by Prince George's County Government and the Department of Family Services.
Okay, Medicaid myths and the must-have document to avoid guardianship. But it might seem strange that the two are paired together, but they actually are relevant. And we'll get to that. So if we can go to the next slide, and let's see if that's myth number one. Okay, myth number one, Medicare will pay for long-term care. So Medicare and Medicaid are very different. Adults of a certain age have Medicare as basically their health insurance. Medicare will pay for the first 100 days of your long-term care stay, and that's it. After that, there's three options. If you've got a long-term care policy, great, but a lot of people don't. So there's two more options. You can private pay, pay from your own assets, or you could apply for the Medicaid long-term care benefit. So with the Medicare, the 100 days, in a sense, it's not a true 100 days. Medicare will pay in full the first 20 days. And then after that, you will be responsible for part or most of, and towards the end, possibly all of the copay. So it's really good to have a secondary healthcare insurance policy to pick up those last 80 days. Now during, so just to back up 1 second, it's not 100 days like only once and that's it, all of your life. It does reset. So if there's been 60 days in between your last hospital stay, and you're in long-term care again, then you can have another 100 days. COVID has relaxed some of these rules, so it's going to be a little variable, and we don't know how long they're going to last. But you can always check in with an attorney to try and figure out, what the current rules are. But that's generally the rule. It's 100 days. Okay, we can talk about myth number two. Okay, I have too much money to qualify for Medicaid. So a lot of people think that this is the case, and you may have too much money, but you still may be able to qualify as long as we can do what's called a spend down, which means that we need to take your assets that are over the limit and spend them down so you can qualify. So most clients come to me, they have somewhere between $50,000 and maybe up to $500,000 in assets. Once in a while, a client will have as much as $1 million. And here is the rule. The rule is if it's a single person applying for long-term care, they cannot have more than $2,500 in assets in their name. That's a very small amount. If it's a married couple, Medicaid looks at the married couple total assets together. Okay, it doesn't matter how it's titled, if it's in the wife's name only, everything is one pot of money. So for a spouse case, you cannot have more than $137,400. Okay, anything that's above that amount would have to be spent down. But the true calculation, what Medicaid does is, it looks at, for the spouse, it looks at the one pot of money. We add up everything together. Checking account, saving, life insurance, cash out values, IRA, 401k, all of that together, all those money assets, add it together and then divide it in half. You can keep 1/2 up to the $137,400. Anything above that amount must be spent down. So that's a term you may want to just keep in mind is the spend down, which means we have to spend the money to qualify. And then the other term you may want to just keep in mind, you might hear it a couple times, is available assets. It means any asset that is available to you, checking, savings, IRAs, 401ks, anything that you have control over and you can cash out. Okay, we can go to myth number four. Myth number four, a trust will protect my assets and money. I just had this phone call literally yesterday. A very nice lady called me. She said, well, I think I want to put everything into a trust. I'm in my early 70s. I want to make sure that if I need long-term care, it'll be protected. I had to give her the bad news that I would be happy to do a trust, but it didn't seem like it made sense. Number one, because if it's in a revocable trust, meaning it could be undone at any point after you've made it, then it's definitely going to qualify. It's going to count towards your assets, okay? And they're going to be considered available and must be spent down. So there's another kind of trust. It's called an irrevocable trust, meaning once you put it in place, that's it. It's done. You've created it. You've titled your assets to it. It cannot be changed. An irrevocable trust, though, however, there's a couple things about it that makes it Medicaid compliant. Number one, it must be made 5 years before you need long-term care. Number two, you cannot have any control of those assets. The trust must be written in a way that you have absolutely no control. You have titled things to that trust, like your house and your assets, and someone else is the trustee of that trust. I once had a client about a year ago come to me, spousal case. Husband was in nursing home care, and they had created a trust about 1.5 years before. It said irrevocable on it, but it didn't have the right language to make it an irrevocable trust. So it wouldn't have worked anyway. It was made within that 5-year time span of needing care, and it was drafted by a young attorney who had just graduated from law school. So be careful of where you go to get things drafted, and just keep in mind that if you go the route of an irrevocable trust, it must have very specific language, and you must basically give up all control of your assets, and that's what makes it unavailable, and it cannot be undone. So that's the myth about the trust. So we can go to myth number 5. Okay, I must spend all of my money on the nursing home before I qualify for Medicaid. So if you're in a nursing home, you might actually be told that by the employee or the business manager normally of the nursing home. You have to spend all your money before you can actually apply for Medicaid. That is not true. You can be in the nursing home. You may even have paid a couple months of the bills, and then you find out that there might be alternatives, that you might be able to preserve those assets. You can absolutely do that. And it's just going to be basically figuring out, okay, is this for a single person? Is this for a spousal couple? Figuring out what the assets are, and getting to a spend down plan and actually doing the spend down. And that could be done while a person is receiving care. So I'll make sure, yes. Okay, so we can go to myth number 6. Myth number 6, I can put all my money in my spouse's name and qualify for Medicaid. This is another common misconception. You have a married couple, so let's say the wife is in nursing home care, and they think, well, we can put all the money in the husband's name and that's going to be okay. Unfortunately, it is not. So like I mentioned, Medicaid looks at the assets as one pot of money for a married couple. And with that pot of money, they look at that up to the date of eligibility. And then once the person becomes eligible, they no longer care about the spouse. They'll never look at their assets again. It's only up until the date of eligibility. After that, the wife who's in the community can win the lottery and it wouldn't make a difference. Medicaid could not make that spouse pay for the other spouse's care. But before the eligibility, before the application is submitted, Medicaid absolutely cares about what the married couple's assets are. We can go to myth number 7. Okay, I cannot qualify for benefits for 5 years because I've transferred assets. So I've mentioned about the spend down. That means that we have to spend money in order to qualify. I've mentioned about available assets, which means any asset that you have access to, you have control over, you can spend. And then another term that's often used is the 5-year look back. So what that means is if you're applying for March 1st eligibility of this year, then Medicaid is going to go all the way back to March 1st of 2017 and take a look at all the transactions you've made in that time period. That's one of the pieces one of the roles I play in helping my clients is gathering all those documents. I go through them. I look for transfers over $2,000. We talk about it, we figure out what it was, and we talk about how to cure that transfer. Okay, cure meaning we're going to somehow justify it. And in most cases, it can be justified. I've seen transfers as much as $80,000. I've seen smaller ones that were done repeatedly over 5 years. A lot of times, most of the time, there's a good explanation for it, and it's not merely for the purpose of trying to qualify for Medicaid. So some common examples that I find in my practice is the parent who's in care made a gift to their adult child. Once in a while, I have a case where an adult child stole money from the parent because the child's name was on the bank account with the parent. Sometimes a parent pays for a divorce. Sometimes the adult parent pays for schooling for the grandkids. Another common one is the parent paid for the adult child's down payment on a home. These things happen. There are a couple ways to cure them. One of them is a promissory note. It's a very specific kind of promissory note that us Medicaid planners, we draft and they are routinely accepted. It has certain language to it that makes it Medicaid compliant. Sometimes we can justify it as a reimbursement. This actually happens more often than not, where the adult child was helping the parent before they went into care. And it could be justified as a caregiving expense. So these are just a couple of examples. There's a lot of way to cure transfers. I had, and sometimes it's just a matter of, I had a more recent client where they came to me, mom was in nursing care, son kind of panicked. He just withdrew $20,000 from his mom's account, put it in his name, and I said to him, just put it back and we'll be fine. So he went ahead and did that. So sometimes we do things we're not sure what to do. It's okay. A good lawyer will give you advice about what to do and how to fix it. Okay, we can go to myth number 8. So Medicaid planning can only be done before going into a nursing home. So that is one kind of planning. You can definitely, if there's a diagnosis of dementia, of Alzheimer's, it's early on, or maybe it's moderate, and you know down the road that it's going to be very uncertain what's going to happen. Not sure how long the loved one can stay at home, and what can be done. There are some things that can be done. There are some specific kinds of trust that can be done besides just the irrevocable trust. The tricky part is figuring out if it's going to be worth doing it. Will it survive the 5 years? So the earlier planning, the better in some instances. But it's all going to be very variable. So we can do pre-planning for sure. I will say that the bulk of my practice is crisis planning. I call it crisis because the phone call is usually something like this. Mom is in nursing home care. They just told me we have to start paying $15,000 a month next week. That happens all the time. So it's something, it's a serious illness, something happened all of a sudden, and the family doesn't know what to do. So that is the most often case I deal with. And so it's a lot of work in a small amount of time, but it's totally doable. It's and there are many things that can be done. So one of the more recent cases I had was literally in January. I got a phone call from a daughter, and she said dad was in nursing care, and it was a facility here in Prince George's County, and they said to her, in 5 days you have to pay us $35,000. She was completely shocked, and it was partly because the nursing home kind of messed up. They weren't tracking the 100 days for the Medicare. It was up, and this person was receiving high levels of care. So that's one of the examples. It does happen. It can be very stressful. I would definitely urge to reach out, whether it's the Department of Aging in the county or a resource like Dementia Friendly America, a lawyer for sure, if you can, because it's a very stressful situation, but there is a lot that can be done. So, okay, let's go to myth number 9. The nursing home told me that they do not have any Medicaid beds, so I must private pay. I get this a lot too. Even with clients that I'm working with who are actually on the Medicare days still, but then are told that the Medicare days are ending and there's no Medicaid beds, but they're in a bed. There's no label on the bed. So this is another stressful situation the family's in because they don't understand what's going on and they're going by what the nursing home is saying. This is not true. If the nursing facility accepts Medicaid, every bed is a Medicaid bed. Some states are a little bit different about this, but Maryland, this is the case. If they have Medicaid certified beds, meaning they accept the Medicaid benefit, all the beds are Medicaid. It doesn't matter. Sometimes I had this with a recent client where he was told, well, your mother's in a Medicare bed and she can't stay in that Medicare bed because it's for Medicare patients, but it's the same thing. It does not matter. It is not a Medicare bed. If you're accepting, private pay, Medicaid benefit, it's all of those beds. So if you're in the bed, you can stay in it. That's pretty much the point on that one. So please don't ever feel bullied into that one as well. That is a common incorrect statement that is told to people. Okay, we can go to myth number 10. I do not need a lawyer for Medicaid planning. Maybe, but I would say if you're in the situation, even if you just you see a lawyer for a consultation, I guarantee you if it's with an elder lawyer who does this kind of work, it will be worth it because there are so many things that can be done. We will take a look at all the assets. I will develop a spend down plan for you. One of the things I do is I take an available asset and turn it into an exempt asset. You can also turn an asset into an income stream. So these are really like, there's many things that can be done. There's many strategies, and I will say that all of them are done pursuant to the Maryland Medicaid rules. So there's nothing funny going on. It's all according to either federal law, which oversees Medicaid, and then when Maryland agrees to accept Medicaid benefits, they come up with some of their own rules, but they model the federal. And so everything I do is pursuant to the law and the rules. So, but there is a lot that can be done. I recently had a family in. Mom is 85 years old. Dad is in nursing care. He's 89. Mom was shocked to find out that we can set aside, I think we figured out about $200,000 that does not need to be spent, and she thought she had to spend it all as private pay at the nursing home. So that's a good result, because especially in a spousal case, you don't want to impoverish your spouse. You want to make sure that the money that you worked very hard for during your life is still in your family and is providing for your spouse. So, okay, financial powers of attorney. A lot of older adults get worried about guardianship. If you're not familiar with what guardianship is, it's basically, it's kind of what's similar to minor children. Someone steps in and will oversee decision making for an incapacitated or disabled adult. In the case of guardianship, the person basically gives up all rights. You now have someone who's going to make all decisions for you. What I try to do to avoid that always is to have a financial power of attorney. It is an underestimated document. There are a lot of clients that I work with that either had no financial power of attorney or they had one that was poorly written, and it creates a lot of roadblocks. It makes the Medicaid planning really hard. It can prolong it, where usually we need to move a little fast in the crisis planning. There are ways around it that I use, but the best thing you can do for yourself, if anything, is to just get a really good financial power of attorney. I would urge you to, consult with a lawyer on it. Make sure it's a lawyer who drafts these on a regular basis and stays up to date on the laws. And just for anyone who's not familiar with what a financial power of attorney is, it basically means that during your lifetime, you are appointing an agent to act on your behalf to make financial decisions. They can pretty much step into your shoes under a general power of attorney and transact business, write checks, collect bank statements, pay your mortgage, maybe sell your house if it's appropriate. And it's done only if you can't make decisions for yourself, okay? Or, you can have it so that if you're out of the country and you need someone to do some transaction for you, you have that done too. It doesn't have to be incapacitation, but that's normally the context where it's used, is that you're not able to make decisions for yourself. Maybe you have a spell of illness and you're in the hospital, you need someone to just step into your shoes for a while. So it's a really important document. When there's not one in place, it's very difficult, sometimes impossible, and then sometimes leads to guardianship. So I try to avoid guardianship at all costs. I like to do less restrictive methods, but sometimes I have no choice, because if there's no other way around it and there's no power of attorney, then that's what I'm left with. And then just to reemphasize, having a really well-written one, I would never download one from the internet. It's going to be missing language. In Maryland, there is a specific law that governs power of attorneys, and it says in part what must be in that power of attorney, like what language. And I had a recent case in the fall where it was missing just one paragraph of certain language that must be in it. And it was basically a warning saying, this is a powerful document, consult with a lawyer. That language was missing. So Capital One Bank was refusing to accept it. It was creating a huge problem for my client because her father was incapacitated. He was ill. She had to access his money. There was a nursing home bill that she had to pay, and she wanted to move him to assisted living. She couldn't do it. So fortunately, there was enough in the power of attorney where I was able to file a petition with the court and request the court to order Capital One to accept it, which I was successful, but it cost thousands of dollars to the client. So something like that could be avoided if a really good power of attorney is in place. So that's a definitely an underestimated document, and one that I would urge everyone to get if they don't have one. So yes, beware of adding a family member to your bank accounts. It may seem as though it's a very easy planning tool. You're getting older, you think, well, it'd be nice to have my son or daughter, or my niece or nephew on the bank account. It can cause some unforeseen problems. One of them is, well, make sure you trust that person. If you totally trust them, then fine. But sometimes it causes an issue. And sometimes withdrawals are made that you don't want made, and then you can't get them back. The other issue is, for Medicaid purposes, when I'm going through bank statements, if there is a jointly titled bank account, like with son and mom, whose money is it? Medicaid doesn't care. They say all of it belonged to mom, the one who's applying for the benefit. So it could be very difficult piecing out whose money was who. I did have a case like that last summer. I was able to work through it. It took many, many hours. It was very laborious. We were able to do it and we got approval, no problem. But it's not the best method. And then the final thing about that is, and a lot of people don't realize this, is that if you have, let's say you have 5 children, but you have only one of your adult children on that bank account, on your death, that money becomes that one child's money. They have no obligation to hand it out to the rest of your children as you would have wanted in your will. It won't matter what you say in your will because it was a joint account and it's considered jointly owned money, and on death it goes to the other joint owner. So it's just something to keep in mind, and just a little nugget of information about jointly titled accounts. So that is it. I may have spoken fast, I apologize, but it leaves room for questions. So if anyone has questions, I am happy to answer them. Otherwise, I might, just go over one more time about the house, because I'm not sure if I covered fully like the home being exempt. So, but that's fine. Maybe it'll come up in a question. Any questions? Anybody?
No, Miss Con. Miss Connor, you can go ahead and unmute yourself. If not, Miss Sherry Melvin.
Hi, can you hear me okay?
Yes.
Okay, sorry. I'm multitasking here, so thank you for taking my question.
Sure.
So does the Medicare cap of $2,000, does that change every year? Or is that, because my mom we're in the midst of this right now, and we've exhausted everything out of her account because she's in a facility, and all of her pension, Social Security is going to the facility right now. She was declined twice, and because of the 5-year look back period. So I don't know if it's going to be another decline, but at this point, I'm just trying to do a charity case because we just can't afford to pay her facility. But that was my question. So does that $2,000 cap change every year?
I'll address a couple of things about what you said. So the maximum that you can have, so it sounds like your mom is single. So the maximum that she can have is 2,500, okay?
2,500.
Yes, 2,500 if she's in nursing care in Maryland.
Yes.
So, and she would have to be under that amount each month from the date of eligibility on, okay? So, and you have to keep her account under that amount. Now you said it's exhausted, so that's probably fine. Each month also, you raise another point. If you're applying for the Medicaid benefit in Maryland, you have to pay your income over to the nursing home. That is considered like your patient responsibility. Medicaid wants to be the payer of last resort. So you pay the income after a few deductions. One is for a personal needs allowance, one is for like secondary health policies. And if there's a spouse, there can be a deduction for that as well. Sometimes the spouse can take the entire income, but that's going to depend. Now, if you're saying there's an issue with eligibility and she's been denied, and it's something in the 5-year look back, and it's something that you cannot cure, whatever the issue is, because you didn't mention it, and that's fine. You could ask for an undue hardship exception, okay? Those are hard to get, but you can do it. It is available as a possibility.
Okay, great. Thank you.
Sure.
Ms. Michelle Jackson, you can unmute yourself.
Can you hear me now?
Yes.
Okay. My question, I have a situation. You talk about the spend down. My mother does have probably more than $500,000 in income. And when you talk about the 2,000, and she has a house that's paid for. Now I'm on the house. I'm on all of her accounts. I know you said basically that'll make a difference, right? Is that correct?
Okay, so you're on her you're on her deed, okay?
Yeah.
And she's got bank accounts that have your name on it.
And
Okay.
as well as stocks and that those kinds of assets.
Yeah. So
And I'm on that as well. I'm joint on those as well.
okay. So the tricky part of the stocks and the 500,000 is going to be you would have to show whose is whose, and we'd have to prove that. Okay.
I have no way of. It's really hers. I mean.
Okay. And that's the common case, is that it's really maybe mom's doing that because she wants it to pass to you directly on death, or maybe it's for the ease of you helping her with the asset.
My mother has Alzheimer's. I should give you that bit of information. Okay. And she's 88, and she's still living independently, but I probably not for much longer. But she won't be. I don't want to put her in long-term care, but I do want to have somebody come in and help her. And I don't think Medicare pays for that, right?
No, not that I'm aware of. I mean, you'd have to check with what might be available, but probably no.
Okay.
But I will say one thing, okay? and I didn't mention it in the myths, but there is in Maryland what's called a home and community-based options waiver, okay? Which
Say
means
that
that
again. What now?
it's home and community-based options waiver.
Okay.
We call it waiver for short, okay? So I'll say it one more time, home and community options waiver.
Okay.
That's basically a benefit that will pay for in-home care, all right? Someone who is a nursing home level of care, but they want to receive the care in the home. The difficulty, if you apply from the community, your mom's living in the community, it is a 8-year waiting list. However, the workaround is that, and it's not everyone's cup of tea, okay? So I'll say that outright. But if you're willing to let your mom go into nursing home care for a few months, we do the spend down, we get her eligible, she's in nursing care, we apply for waiver while she's in the nursing home, she's put at the top of the priority list, and she'll be home in a couple months with in-home care. So that's not what everybody wants to do. I respect that, but I just want to state it as an option.
So how long do you have to stay in the nursing home? 2 months, you said?
I mean, if we do pre-planning, like we know we're going to do this, then I'm going to work with you. We're going to develop a spend down plan, okay, to see what we can do to preserve her assets, get her financially qualified, meaning at the $2,500 mark.
Now that's
Okay.
another question. What if her income, like her, she doesn't have Social Security. She was a teacher. It's a long story. But what if her pension and her income is more than $2,000 coming in per month?
That's fine. Well, you'd have to give me the exact number, because for the waiver, there is going to be an income cap, but you might be within, but you'd have to get me the exact number.
Okay. And is your last name on the screen? It says Brandi, Jennifer Brandi. Is it Brandi, Brandi?
That is my last name.
Okay.
I know,
Okay.
it sounds like a first name.
Right. That's why I just want to make sure. Okay.
It's Italian, so.
Oh, okay. All right.
I'm not Italian, but it's Italian.
Okay.
Yeah.
I think I'm not gonna take up much more of your time. I don't know who else may have questions. That was pretty much the bulk of my questions. I appreciate you.
Yeah, no, you're welcome. And I want everyone to know that they're free to give me a call as a follow-up. I'm happy to talk to people by phone, for a follow-up. And if you feel like, you want to just ask a little bit more, that's no problem.
Was your number on the I probably missed it.
It might be on that last slide, but I can say it now if that's okay.
What is it?
It's 30. It's actually written wrong.
Uh-oh.
It's here, let me give you the number since it's wrong. It's 301 699.
699?
Yeah, 699 3100. Sorry about that.
And what was the rest of it? Sorry, 699 what?
3100.
Okay. Thank you.
You're welcome.
Okay, Miss Pamela Talley, you can go ahead. You can go ahead and unmute yourself. Miss Pamela Talley.
Just a minute. Thanks. Can you hear me?
Yes.
My question would be, what advice would you give someone if they were, going through this, who was, diagnosed with dementia, but they have a young adult, a vulnerable young adult who has a significant disability, and they wanted to try to protect their assets for that child's care?
That's a great question. And that is one of the exempt transfers, which I love about the Medicaid planning, is that if you have an adult child with a documented disability, okay,
Yes.
then part of the spend down can actually be putting that money in a special needs trust for the child. And that could be the spend down.
That could be the spend down.
Yeah, yeah, and then it becomes an exempt asset, and that adult child that has a disability is provided for.
Okay, so is it something like, and I know I don't want you to get really specific, is it something like a certain amount is put in per year until we get to that, you probably get to that spend down limit or something like that? Is it something along those lines?
What I would do is if the long-term care is imminent and you have someone with dementia and you think that it's imminent, then
Yes.
I would just transfer it all at once, you know. It probably does require a longer conversation, but
Yeah, I don't want you to get.
no, it's okay. But the most common scenario is going to be where, you know, the care is kind of imminent or it's coming like in a year or two.
Yes.
So what I would, if it's not for like a couple years, I would say to the client, well, just hold on to your money. You may need it for yourself, you know. If you want to set it up now and put some money aside, that's fine. You can do that. Or you could just do, if it's like long-term care 2 months from now, let's just put it all in the trust now, you know. So it kind of depends.
Okay.
Yeah.
If you don't mind, could I have one follow-up question?
Yeah, go ahead.
If there's a power of attorney that it has been developed, could that person who is the successor of the power of attorney, could they do it, or does it need to be done by the individual? I mean, is that something, you know, if the spouse is the power of attorney, could they do it when the time comes, like transfer the money into a trust?
Okay, so it sounds like your question is there is a power of attorney, there's an agent named, and there's a backup agent who needs to act. Okay, so what I would do is I would draft what's called a certification of power of attorney, which basically says that the first named agent is not available and the backup agent is serving. And so you would take both those documents to do what you need to do.
Okay, thank you. This is really helpful, and thank you for your telephone number. I'll be calling.
Okay, you're welcome.
I'll mute myself.
Great, thank you. And then we can have Miss Ann Connor, if you're able to unmute yourself. I guess you didn't have a question. Okay. We can go Arlene Reese, if you can unmute yourself. Arlene Reese. Go back later. I'll have Miss Joyce Bailey.
Yes, I wanted to find out, is there a home care insurance? Because I have long-term care insurance, but it has to be done in a nursing home. So is there any way to have home care insurance?
So you have a long-term care policy and it must be in the nursing home?
Yes.
Okay. Usually the long-term care policies will have like an either or. They'll pay like a per day price. So I'm a little surprised, but I guess that could be a possibility. I don't know of any specific like home care insurance though.
Okay.
Yeah.
That's what I thought. Thank you.
You're welcome.
Okay, and then we will have Miss Sherry Downing.
Hello, can you hear me?
Yes. Hello.
Wonderful. Hello, Miss Jennifer and Miss Crystal. First, I want to say thank you guys for sharing this valuable information.
You're welcome.
It's so many times that people wait till the last minute to, when it hits them. So one of the things I want to take back to my friends and family is that, first of all, you want to look at things at least 5 years in advance. What I also wanted to know, my mom now is 80 years old. She's pretty alert. She's doing good. But I have 3 siblings, and we are trying to recognize that this is the inevitable. So what would you suggest to us, the 3 of us, that we do to align ourselves? My mother has a home. She does not want to go anywhere, but she wants to age in place. My sister lives with her. And I'm trying to tell my siblings we need to start doing some type of trust or something, because it could happen at a blink of an eye. What would you suggest we do as a family?
Well, so one of the most important things is if your mom has cognitive ability to do a financial power of attorney, she should definitely do one, because that's going to it's one of the most important documents. If she gets sick all of a sudden, or as she gets older and declines and needs more help, you're going to need that document, so that way you can take care of her financial matters. All right, so that's the biggest one. I mean, she should have a will, of course, because that way she can name her personal representative. She can say how she wants her assets divided. So that's also an important document. But that power of attorney is going to really, help the family when she can't do it herself anymore. Now, you mentioned that a sister lives in the home. There are a lot of things I can do with the home. Now, generally, it's an exempt asset for the person who's applying for Medicaid, okay? It's not something that could just be sold or taken. But if what you're saying is if mom has an adult child, your sister, living in the home, caring for her for more than 2 years, the home can actually be transferred to your sister in a
Okay.
Medicaid planning context, okay?
Okay.
That is within the Medicaid rules. It's not anything she has to do right now. You don't have to do it right this moment. It's something you can do down the line. But that is a way to protect the home. So, like I said, the home is an exempt asset for your mom. So even if your mom goes into long-term care tomorrow, all she has to do is say on the application she intends to return home. Even if it's not realistic, it doesn't matter. If she says she intends to return home, that home is exempt, meaning she doesn't have to sell it. But the danger is that Medicaid could put a lien on it. They rarely do, but they're allowed to according to the rules. The more common scenario is at death. Medicaid will file a claim in the orphans court, okay, so that when the estate is opened, that claim has to be paid. They can only ask for what they paid for your mom's care. They can't ask for a dime more, but they can ask for whatever care that they paid. So one way around that to keep the home truly protected would be to transfer it to your sister, assuming that your sister is still living with her, for the 48 months prior to applying for Medicaid. Does that make sense?
It sure does. And because my sister is still working,
That's
we're seeing that she's having just little where she may need home care periodically.
Yeah, and you'll have to make, she's 80. You could put her on that waiver list that I mentioned, the home and community-based waiver. It's an 8-year waiting list, but your mom might be fine for the next 8 years. We don't know.
Okay.
You can go ahead and do that now. And then when it comes time, you'll have to spend down though, to be approved for that program. So you'll be in the same situation of, figuring out the spend down if she has too many assets. But that is something you can do now too. You can put her on that wait list, make sure she has a good power of attorney. And that's kind of it, trying to assess, figure out her assets, see, how long can she live in the home? How much money would need to be allotted each day? How long will her money pay for that care? You can try and do, a little bit of budgeting now, knowing that it might change depending on what her care needs are.
But thank you so much. I just hear so many horror stories
Yeah.
about even when apparently if they go into the emergency room, that they have to stay in the emergency room a certain amount of days before things are covered by Medicare. I just hear so many.
Yes, and okay, so the rule normally is 3-day hospital stay. And the third day cannot be the discharge day. So it's really 3 days and then discharge. So you need that full 72 hours. But again, right now, because of COVID, a lot of these rules are sort of relaxed. So, and it's kind of like a changing landscape, but that is the general rule. It's a full 72 hours in the hospital, and then you get discharged, and Medicare will pay for the 100 days of rehabilitation or long-term care.
All right. And the District of Columbia, because we are on the Washington, D.C. line, so many of, our friends and family live in the district. Would you say that it's better to be in the District of Columbia versus in Maryland?
It depends. So if we're talking about Medicaid planning, then I know in the district, if you have an IRA, they considered it unavailable. You don't have to cash it out. That's a huge difference. So if your main asset is an IRA, then you want to go to DC.
Okay.
Like you don't want to be in Maryland because you got to cash it out, and like we got to do something else with it. So and then in Virginia, for example, if you have a family member there, there is no wait list for the home waiver. There's none. Yeah, so that's a huge difference as well. So that's a good question.
All right. Well, I'm looking forward to next sessions. This is awesome information, and thank you, ladies, again.
You're welcome.
No problem. Thank you. And we can take one last question. Toya Price, if you can unmute yourself. Toya Price. Miss Veronica Robin, if you can unmute yourself.
Okay, can you hear me?
Yes.
Can. Okay, great. You touched on it a little bit earlier. Thanks for this information, by the way. My mother has dementia, and when we started this maybe 3 years ago, 4 years ago, she was above the cap for Medicaid. She has a home, which I'm living here with her. So I'm wondering, I guess, at what point or where would I go from this point? She pretty much, her monthly expenses are definitely well taken care of, house and everything. It's just that we did not, or she does not qualify because she's above the cap.
So what do you mean she's above the cap?
She, her monthly, I think we were told, but I think you said it was $2,500 a month. And she's something like, I think it's only like 45. It's a little under 2,600 of receiving her monthly pension each month.
Are you saying she's under, she has too much income for the waiver?
Yes, exactly.
Oh, okay.
Now, it may have changed. We live in PG County. I know there has been a couple things that have changed, like over the last 7 or 8 years before her decline. And so I'm just wondering what we should do. She's wanted to stay home. She's still slightly independent, but since COVID, she has declined. So we're trying to keep her here for as long as, as we can. We're gonna put her back in daycare. Hopefully now that COVID is kind of lifted a little bit, some things. So, but we can't do that every day. Her income would not allow for her to go into daycare, every day. So we're trying to do a little bit, have someone come in, let her go to daycare sometime, and then, we kind of, my sister and I have been trying to, care for her for as much as we can for as long as we can.
Yeah, I need to check the 2022 numbers for the income. I didn't check it before this.
Okay.
So, but you might be right that her income is just a little too much. I do feel like there was talk last year, and I'll have to see where it's gone on this, in terms of what to do with excess income. I don't know if anything's changed. So, I mean, feel free
Okay.
to send me an email, and I'll try and look to answer your question, because I just don't know off the top of my head. And Maryland is a little
Okay.
that way, because in some states, when there's excess income, like the income is over the waiver limit, then a special trust could be set up. But as of last year, there was still nothing we can do about that, which is very frustrating.
Mm,
So that way people can qualify even if they have a little too much income, because she's probably right at like the point where she could qualify. So yeah, so feel free to send me an email. Let me see if I can look into it. My email is Jennifer, JENNIFER
mm-hmm.
at brandylawfirm.com, and Brandi has an I at the end, so brandylawfirm.com.
Okay.
Yeah,
Okay. Thank you so much.
yeah, you're welcome. I'm sorry I don't have the answer right now.
Okay, no problem. I appreciate it.